Peace, y'all. Welcome back to Low Life Academy's YouTube channel. If y'all can only see us before these presentations, we're on like, take 150, trying to get this information to you in the best possible way, where it's easiest to understand and you're able to maximize that information to make some informed decisions. So, with that being said, we're just going to get into the video. If you're new to our channel, please make sure you subscribe. Make sure you hit the notification bell. And if you are one of our returning listeners, we thank you for your continued support. So, let's get right into it. Today's topic: the truth about Minnesota Rule 220, as presented by Yousef L. And we'll be in the background providing some feedback. All right, so let's just get into it.
This is Yousef. Was up late tonight, decided to make a video about this Minnesota Rule 220 that everyone is talking about. That there seems to be so much confusion surrounding. I had prepared an introductory speech, but I'm not going to waste your time with that, insulting people and everything. Just take a look around the internet after you watch this. I just want you to Google, put Minnesota Rule 220 into Google, put it on YouTube, and just look at all of the plethora of different videos and products and things that people are trying to sell you behind this Minnesota Rule 220. So without further ado, let's get to it. It's coming off my website. I'm going to make it bigger. I'll make sure that everybody can see it. Okay, that should be big enough. All right. Now, I wrote a article on my website, highfrequencyradionetwork.com, and I sent out an email, and I decided to do a video. I thought a video would be very good to do about this, and I titled the article, "Is the Minnesota Rule of Practice 220 saying what all the gurus say it is?" by Yousef. Now, let me read this to you. And the reason I'm reading it is because I've already put the links in and kind of like narrates my story a little bit of how I went about researching this Minnesota Rule 220. Because, there's some individuals out there saying I didn't know how to read and all this kind of stuff. And I mean, I was just amazed. First time I read Rule 220, I had a good sense of what it was talking about. But it wasn't until I was kind of compelled to do the research on this to demonstrate that not only did I know how to read, but that the individuals out there who are selling you all this stuff, they don't know how to read. And you need to really think about that, because there are individuals out there selling this information to you on a faulty premise. And you, all of you who are listening, you need to take more responsibility for yourselves and investigate this information thoroughly before you go about and start trying to utilize it and, jump on all these bandwagons and everything. But anyway,
I'm not gonna let Yusuf just blow past that, as he said anyway, because that's very important. That's part of the whole reason why we came to this platform, because we know some of you all are visual learners, and some of y'all are audio learners, right? Audio learners. So we wanted to provide you all with access to information so you can make an informed decision. All Yusuf is saying here is make sure you put in your due diligence. So I didn't want to just blow past that as if it's not important. But let's hear what he has to say.
name of it again, okay, by Yousef. It says there's a movement that has escalated among the redemption circles of a process involving birth certificate authentication in order to become the registered owner of one's estate. This process is colloquially referred to as Minnesota Rule 220, which incorporated portions of the UCC and Article 4, Section 1 of the U.S. Constitution, which is the full faith and credit or comity clause. Now, I want to stop real quick and talk about this word Minnesota Rule 220. Okay, to me, this is the foundation of the problem. Is number one, they're not saying what the entire word is. It's Minnesota Rules of Practice 220. Okay, first and foremost, it's not Minnesota Rule 220. And there's a difference between a rule of practice and a rule of court, which I'm going to show you in just a second. These are rules of practice. Okay. Now it goes on, it says, well, I'm not opposed to authenticating the birth certificate for additional layers of security as it relates to travel purposes. And the reason I said that was is because when you go to the federal website, that's what it's for. It's for traveling in different jurisdictions. That's why they want you to authenticate the birth certificate. So if you're in a foreign jurisdiction, you have something that the government itself has put their stamp of approval on in this foreign jurisdiction to demonstrate that you are who you say you are. Now it goes on, it says the sheer absurdity of locating an obscure rule of practice in a foreign jurisdiction and attempting to compel clerks in other states to recognize it was astounding to me. I took some time to research Minnesota Rules of Practice 220 regarding the birth certificate in order to determine if what the so-called gurus were saying was true or whether it was a misinterpretation that individuals took and ran with.
Pay attention. He just went over the fact that this is cited as the foundational document giving rise to authentication. He's not saying all of these things. He's just saying, is it what they are telling you that it's supposed to be? But he's talking about authentication, people, right? So, and the issue with the authentication piece, as he said, he has no issues maximizing that service as it relates to travel. But the issue is people are telling you that it removes you from some jurisdiction. All right. So let's see what else he has to say.
First, look at what a rule of practice is. Using Bouvier's 1856 dictionary, we quickly come up with the definition. And I put a copy of Bouvier's on here as a link. You can click on it and it will take you over to the 1856 edition of Bouvier. And right here, we can see, first of all, what a rule of court is. A rule of court, an order made by a court having competent jurisdiction. Rules of court are either general or special. The former are laws by which the practice of the court is governed. The latter are special orders made in particular cases. Disobedience to these is punished by giving judgment against the disobedient party or by attachment for contempt. And the word attachment means a warrant for an arrest. So when you get a court order and you refuse to follow a court order, they'll come and arrest you. Like in the case of child support. Child support, if you don't pay it, that is called a contempt of court. They're not arresting you because you didn't pay child support. They're arresting you because you didn't follow a court order. Same thing. If the woman takes the kids out of state and you want to go into the next state and you get an attorney over there, the first thing the attorney is going to say is, do you have a court order? Court orders are enforceable. These are court orders. All right, so let's look at the difference between a rule in court, a rule of court, and rules of practice. So here we got the rules of practice. Remember, it's called the Minnesota General Rules of Practice 220. Remember that? Catch that? Okay, now what is the rules of practice? Well, certain orders made by the courts for the purpose of regulating the practice of members of the bar and others. Every court of record has an inherent power to make rules for the transaction of its business, which rules they may from time to time change, alter, rescind, or repeal. While they are enforced, they must be applied to all cases which fall within them. They can use no discretion unless such discretion is authorized by the rules themselves. Rules of court cannot, of course, contravene the Constitution or the law of the land. And that goes to the judge, too, because these are Article 1 courts. These are statutes. These statutes are promulgated by the legislature, and the legislature will dictate what the officers of the court do, the attorneys, and everybody. They're the masters over all of this, or the legislature.
All right, I let him go on for a little bit on that one, because you all needed to get the clarity as he's going to dig further. We're not going to be able to take in all of that. I'm not doing another 40-minute video. So unfortunately, you're gonna have to go back and listen to this and apply your own mind and your own expertise and information. So I'm gonna skip ahead in the video, but what he's sharing is the foundation as to where Minnesota Rule 220 comes from. All right. So let's see. I think I want to share this part. So let's go here.
And here we have it. Minnesota 527.405 conveyance by a custodian. Oh, and what do we have here? We have an affidavit of the custodian.
All right. So what you're gonna find when you go back and listen to this video, Yousef goes into where all of this stems from, and ultimately, he's going to lead you to. I think it's this section here, as I'm skipping through. I'm not playing it all over again. And then why is this thing not
And
loading
I
up?
just read this.
Okay.
So, as we can see from the above, the Minnesota Rule 220 is a codification made for situations where a minor under the age of 18 may receive a conveyance of property from a custodian. This has nothing to do with the Uniform Commercial Code or any of the things that you're being told.
All right. So, as you can see on the screen, what you will find is that the perspective given is just as he stated, right? It's a codification for transfer of property from a custodian to someone who's alleged to be a minor, right? So that's the perspective. All right, let's continue.
As a matter of fact, Minnesota provides you with a copy of the certificate of title that they are referencing. You can find it at Minnesota Statutes 508.35, Form of Certificate. All right, so let's look at that next. Let's click on this. And what do we have here? Oh my goodness. It is the damn certificate title. I mean,
I'm sorry, y'all. I had to pause the video. He would just be cracking me up. He said, "Oh my God." But yeah, look at this. You all, for the life of whatever, have been going back and forth as to what you need to do with Minnesota Rule 220. So let me just acknowledge Yousef for taking the time to point these things out to y'all. Hopefully this makes sense and y'all can go back and do your research. Make sure you check out this video too. All right.
508.35. The certificate of title should contain the name and residence of the owner, a description of the land and of the estate of the owner therein, and shall by memorial, registration of memorials, contain a description of all encumbrances, liens, and interests in which the estate of the owner is subject.
I just had to chuckle. Registrations of memorials. That's how many times it takes for you to read, Minnesota Rule 220 or Minnesota Rule of Practice, Rule 220, for you to, be able to mimic certain things. But this encompasses exactly what Minnesota Rule 220 describes. So I'm going to stop here as far as the video goes. You all can go check it out. The video recording that we did earlier, went in depth. Like I told you all, it was almost a 40-minute video. So we're just gonna pause it right here. What I am gonna do is just add a couple of things um to this presentation. So, all right, let's look at it this way. So, one of the things that this does is that it clarifies the difference between authentication of the birth certificate versus certificate of title, right? The authentication is used in terms of evidence just to present evidence, right? But this certificate of title demonstrates ownership. So, no matter how you spin it, it's just going to come back to ownership, ownership, ownership. Now, the language here, as you can see on the form, it describes exactly what Minnesota Rule 220 said that we were supposed to incorporate, right? So this is it right here. Now, what are some of the things that you all are not aware of as it relates to this whole authentication piece? So let me start here. and give you all a little perspective. All right. So as it relates to birth certificates, proof of the age, I'm not going to put this on the screen. I don't want to, right? So a lot of the information that we have, we want to protect that resource. We have an upcoming webinar on February 18th at, I believe it's at 1 p.m. It'll be up on the website. It is up on the website. We're going to ask that you all take the opportunity to go to our website. It's lawlifeacademy.com. You're going to go in and you're going to create, pretty much a free account. And once you subscribe, it give you access to different information. One of the things that we are going to provide to our YouTube subscribers is that we're going to provide them with the ABC Express Trust information. So once they subscribe, once they sign up and they can show proof, then those subscribers of YouTube would also be given access to our private, well, it's really public, but for the purposes of our private community, it'd be a private YouTube subscribers platform, if you will. So we'll be able to have do a little question and answer, and that's where we'll do the free webinar that we discussed. So all those links are already set up. If it doesn't make sense, I apologize. It's just that it's been a long day with this whole upload with YouTube, the deleting, the whole back and forth. So I'm a little bit frustrated, but you'll be able to go in and take advantage of this stuff. All right. So birth certificates, what it says here, proof of the age of person, right? When they're not available to testify, in most cases through use of the subject's birth certificate or at least a certified copy thereof, right? So all you had to do is just use the BC or a certified copy of the BC. Birth certificates are prepared by physicians, professional attendants, and other authorities acting in a public capacity and are usually filed in the vital statistics office of the state, county, or city in which the birth occurred. There's so much meat and potatoes to this. We're not going to get through that today, but I just want to present this to y'all because this has a little bit to do with authentication, at least this blurb here. Once obtained by the attorney, which Yousef just mentioned, those rules to court were for the people that are practicing at the bar and others, right? So it says obtained by an attorney, right? Through the appropriate office, certified copies of birth certificates qualify as public records and are admissible in evidence. I keep on trying to tell you, evidence as proof of age. That's the most that you can get out of a birth certificate is proof of age, right? So they say where local requirements as to authentication are met. All right. Admissibility of birth certificates is provided for in many individual state statutes and in one of these laws and in the federal rule of evidence. I'll just leave it like that. As evidence of a person's date of birth, as evidence of a person's date of birth, y'all keep claiming that it's the name and that it's everything else under the sun. But as evidence of the date of birth, birth certificates are not regarded as conclusive, right? So it's not just final, right? But they are treated as prima facie evidence to the facts set forth in them. Now, what we're saying, they're talking about person's date of birth. Now they're talking about all the facts that are set forth in them. Pay attention. And at least one court has characterized them the most probative evidence of their subject ages. All right. So if I skip over some of this and get down here, authentication requirements for copies of birth certificates, sometimes governed by statute, may vary from one place to another. But in most jurisdiction, they are easily satisfied under the federal rules of evidence. Authentication is accomplished merely by having the copy certified as correct by the appropriate custodian. That's all they did. Merely. See how meager that is? No extrinsic and no extrinsic evidence of authenticity is required. Certified copies of the birth certificates have been held to be self authenticating by many state courts as well, with at least one such court stating that no witness is needed to introduce such a document. In cases where copies of the subject's birth certificate are not available, as where the birth was for some reason unrecorded, copies of their public records may be admitted to prove age under principles similar to those discussed above. These include census record, selective services record, school record, motor vehicle records, so on and so forth. So they'll use other things to identify your age. So again, their laws, not ours, or not mine, I should say, telling you that a birth certificate is already held to be self authenticating. So why are you doing the same thing? Now, let me share this also because I was jumping around as it relates to this and I wanted to add some more meat and potatoes. So, as it relates to the certificates themselves, right? These certificates shall include a minimum, whatever respective standards that have been recommended by the U.S. Bureau of Census. Go back to the last video I did. I try to show you all the framework, the foundation, so you can get those things done and get that perspective. So, uh, prima facie evidence. So watch this. Birth certificates which have been filed within a time frame after the time prescribed therefore shall be prima facie evidence of the facts therein stated. So if you have a birth certificate which has been filed by a certain time frame, it's been held to be prima facie evidence, right? Up until 1974-ish. Go back to the video that we did with what's his name? Johnny, I forgot his name. Is it Carson? Carson, Johnny Carson, where the attorney came out and talked about, what is his name and the fact that that's hearsay and all of this stuff. So let me go into a little bit more why he was able to do that. So it says here, information pertaining to the father of a child are considered prima facie evidence only if the alleged father is the husband of the mother. Y'all heard that? That's the only time that is prima facie evidence, right? If not, the information pertaining to the father of a child are not evidence in any proceeding adverse to the interests of the alleged father, the father's heirs, the father's next of kin, devisee. When I tell you this is the whole corruption of blood stuff, right? So I read over that. Let me jump down. There's a little bit more that I want to share before I go. Um, where is it? I think I met. Oh, here it is. All right. Disclosure of illegitimacy of birth or of information from which it can be ascertained may be made only upon order of the court of a competent jurisdiction in a case where such information is necessary, right, for the determination of personal property rights, and then only for such purposes. So, birth records of the state shall be open to inspection by, and it shall not be necessary for said individual to obtain an order of the court in order to inspect records of illegitimacy that they have secured. So I wanted to just add that piece in there just because people don't talk about that, but they actually have laws that play into all of these things. Right. So at the end of the day, I just want to make sure that you all have an understanding. You need to stop authenticating. It doesn't do anything because you are not using or maximizing it for the purpose that it was intended. The only challenge to the video of Yousef is the fact that, um, we know that there's something going on with the BC. Let's leave it like that, right? But what action, what course of action, what steps need to be taken wasn't discussed in Yousef's video. So that's why we're still going to go ahead and present our webinar on the 18th because we're talking about claiming the actual birth certificate. So if you want to be a part of that, you want to go ahead as soon as you can and create a free account. Then you can go in and you can take advantage in our resource center. You can take advantage of the upcoming webinar. So you just click here and then you can go in and sign up for that. All right. We're gonna end it here because we're approaching that 30-minute mark. But yeah, we'll just end it here. If some of the information got away from us, I apologize. I tried to do the best that I could to come back to and revisit a lot of the things that I talked about earlier. But again, this is our 100 and something tape because I kept making little mistakes here and there that I wasn't pleased with. All right. So if you're if you're new to the channel, please make sure you subscribe again. Make sure you hit the notification bell. If you want more information, join us for the webinar. You can go to lawlifeacademy.com and check out that webinar. Give it until tomorrow morning because I just had something come up. But yeah, you should be able to sign up tomorrow and take advantage. So look forward to seeing those that will participate, and hopefully you all enjoy this video. Peace.